All right, welcome everybody to the evening session of our October 18th regularly scheduled commission hearing. And this is the one evening a month where we take exclusive public comment in the evening time, and looking forward to hearing from, I believe we have 5 folks signed up for public comment today. And before we get started with that, AAG Davenport has a comment he's going to make before we start with public comment. So AAG Davenport, if you are ready, we are ready for you.
Thank you, Chair. I just have a brief statement about the topics of public comment this evening in relation to a matter that's ongoing before the Commission. Starting last Tuesday, August 10th, the Commission began an adjudicatory hearing on the matter of staff of the COGCC v. KP Kaufman, docket number 2011-00261. The Commission provided opportunities for the public to comment on that hearing before the hearing began. That hearing is ongoing and will continue at least through next Monday, August 23rd. Last week, the Commission had occasion to decide whether to accept a public comment on the KPK enforcement matter, which was submitted after the hearing began. To maintain a fair hearing that provides parties with due process, the Commission decided it would not be appropriate to accept that comment into the record, and that it would not be appropriate to consider that comment. Consistent with that decision, the Commission will not accept public comment tonight on the KPK enforcement matter. Should a commenter begin to speak to the KPK enforcement matter tonight, we will interrupt to request the commenter move on to a different subject.
Thank you, Mr. Davenport. I think that sets the stage for give us some, I guess, sideboards for comments tonight. Otherwise, we look forward to hearing from our commenters on all other subjects. Ms. Larson, are we ready to bring our first public commenter on? I believe that's Mr. Claflin. If I have pronouncing that correctly, I hope.
We will bring him into the meeting.
Mr. Chair.
Commissioner Messner.
I do think that typically on Wednesday evening meetings, we do give folks 5 minutes instead of 3 minutes. Is that correct?
That's my recollection. So we will change that. See, Ms. Amaro is changing that now. So we will give each public commenter 5 minutes to share their comments with us. It looks like Mr. Claflin, and again, I hope I pronounced that correctly, has been elevated to a panelist. If you would like to unmute yourself, you are welcome to begin at any time.
All right, thank you. I just need to arrange my paper here, but the extra two minutes is nice. Thank you. Can I start?
You sure may.
My name is Brad Fang. So good evening, commissioners. I know you've had a long week. Unfortunately, you have more problems ahead. Next week, you will start deciding on the first oil and gas development plans to be filed under Senate Bill 181. The Wildlife and Biological Resources Coalition 350 Colorado and the Colorado chapter of Sierra Club urgently call your attention to the fact that these applications and the processes that led to them are not ready to go forward. They need to be put on pause while you resolve these issues. I've spent dozens of hours poring over these OGDP applications, and I must say that they reflect the industry's pre-181 mindset of conducting business as usual, not the new post-181 mandate of preservation. Somehow, we're in a situation where the hearings are next week, but you and the public do not yet have staff's recommendations or proposed conditions of approval to review. The public comment periods have closed, the protest periods have closed, and staff still has not provided their recommendations, perhaps the key piece of analysis in this whole process. We and you need to see staff recommendations and COAs to ensure that COGCC is upholding the mission change mandate to protect the 181 values. I would note that the applicant due up for hearing on August 27th has filed a motion to approve the application without a hearing. and apparently before staff delivers its recommendations as well. We urge you to refuse this. This isn't the old days anymore. We strongly request that once staff has finalized their recommendations, that the public comment and protest periods be restarted, so both you and we can have adequate time to process and respond to staff's determinations. Anything less makes it impossible for the public to participate meaningfully in OGDP reviews. Going forward, it may make sense for you to retain the current protest process for disputes over real property issues, which other oil and gas companies may have. But the public comment process should be on its own track. That process should have the following steps, we believe. First, filing of the application, then the completeness determination, after which public review can start, then staff recommendations, after which the public comment period can start. Following the public comment period, you should decide on the application in a public meeting where you can interact freely with the public to resolve the public policy issues, not a lawyerly process that shuts the public out. The second recommendation concerns the applications themselves. The applications I have reviewed contain so much conflicting information. Part of the problem is that an OGDP consists of several dozen separate documents written by different people: consultants, the applicant's lawyers. There is very little internal consistency in these applications. The Form 2A will say one thing, and supporting documents will say something very different. The public isn't even sure of how many documents are part of the application. We recommend that going forward, you require applicants to file one OGDP document which can be read as a unit, rather than making reviewers wade through the conflicting mishmash of files which now are submitted. Simplifying and rationalizing the processes will make everyone's life easier. Thank you for your attention to these pressing matters.
Thank you, Mr. Clefane, for your comments this evening.
Thank you.
Up next, I believe we have Ms. Heidi Leathwood.
Yes, we will bring her right in.
Hi, Commissioners.
Hello, Ms. Leathwood. We are ready when you are.
Okay, thanks for hearing public comment tonight. I know you've been really busy, and I've been able to take advantage of some time off that I've had to be able to watch you in action. And I just want to thank you for all of your hard work and skillful and attentive work. I'm not sure if I'm allowed to say that, but I do thank you. I want to also tell you that I agree with the person who commented before me, and I agree with all of his comments and recommendations. And also, I've looked at the OGDP applications and been very confused. I have been unable to find any of the documents that the application says are a part of the application. So I want to echo that. And then I would just want to talk about climate change. There's so much dire news about climate change lately. And I want to ask you to consider that climate change is an adverse impact that results from oil and gas operations. And I know I've said this before, but you are empowered by the Act to consider it. I know that it's not in your rules at this moment, but I know that you can go back and make rules afresh. The Act requires mitigation of all adverse impacts resulting from oil and gas operations. And so it is still possible to include this in your 700 series rules. Your current rules mainly deal with the mitigation and the remediation of effects to soil and water. And so do the proposed straw dog rules. It's not as easy to imagine how to address impacts that do not remain on the boundary of a facility, like air and climate. but I and many other members of the public really urge you to do this. Impacts to air, including impacts to climate, are adverse impacts resulting from oil and gas operations, and addressing adverse impacts is an obligation under the Act. And that's all I have tonight, and thank you again for your diligent work.
Thank you, Ms. Leathwood, for your thoughtful comment as usual. Up next, I believe we have Ms. Marie Venner.
Thank you, commissioners. I realize this has been a tough week, and if you can find your way to implement the recommendations and requests I made tonight, it should make your jobs much easier and more straightforward, and also enable you to do right by Colorado law and your obligation to protect Coloradans in our shared future. Colorado's Small Business Alliance and many statewide and local groups ask for the Commission's focused attention on promises made to the people of Colorado 2.5 years ago now. We are still waiting, and your urgent attention and action is required. Colorado's projected emissions are far from the 2025 and 2030 statutory levels, and no concrete regulatory proposals are on the table to cut pollution to those statutory levels on the necessary timeline. No new drilling and permitting should be allowed in Colorado. More LDAR and eliminating flaring are good, but the people and businesses of Colorado depend on the livability and viability of life in our state, not to mention health. This past week, I read about UCD health research that found cancer effects up to 10 miles from multi-wellhead sites. Both the International Energy Agency and the International Panel on Climate Change scientists have made it clear that no new drilling should occur. Once again, no new drilling should occur. IPCC scientists from Group 3, the group in charge of analyzing how to reduce emissions and to mitigate impacts, developed a draft summary for politicians that said, no, quote, no new coal or gas plants should be built, and the current ones should reduce their useful life, which is typically more than 30 years to around 10 years. So that means that these should be phased out in the next 10 years. This is, we definitely should not be increasing production or permitting any more production as is occurring now in Colorado. The remaining worldwide carbon budget to get on a 1.5C track. Of course, we've seen the disasters in the US at just 1.1 degrees, including temperatures over 120 degrees in Canada. But in order to stay below 1.5C at a 67% probability, that leaves just 400 gigatons of CO2. To have an 83% chance of avoiding this catastrophic level leaves just 300 gigatons. And this is from the beginning of 2020, not taking credit for earlier reductions back to 2005, as we're doing in Colorado. So this is 5 years of emissions for the entire world at the current level. Internationally, we've been advised to cut these in half. Scientists have told us this, but the US Fair Shares analysis shows that we should be cutting it at twice that level. And that is exactly the opposite of this plan to increase production by 30%. Finally, you are responsible for financially protecting the people of Colorado. Many wells in Colorado are only covered for about $1,000 to close right now, when closure costs are closer to $300,000 according to Carbon Tracker. I'm not sure if this includes site remediation. The $78,000 figure used in the draft rules is not representative of the full cost to plug and reclaim a well. Full cost bonding should be required for all new wells. This is known and done in North Dakota, in Alaska, I guess more experienced states in this area, and we should follow their example. Full cost bonding should also be required for all well transfers. Tiers 1 and 2 in Rule 702 should be eliminated. The inactive well requirement should be clarified and strengthened. The Commission's rules must apply to federal wells. Surface owner rights should be expanded and unreasonable omitted as a damage criteria. And there should be a catastrophic adverse impact fund, as well as a climate effects fund. Colorado regulations have rarely been unreasonable, and opposition tends to misstate and greatly overstate potential harms. This is a pattern that's been documented over and over again.
Ms. Venner, I'm sorry, but your time has expired.
Yeah. In fact, regulations that address air pollution produce health and economic benefits in the range of 30 to 1 for their cost.
Ms. Venner, your time has expired.
Ms. Venner, if you would please send that to us. It looks like you're reading your comment. We'd love to read it.
Yep, I was on the last sentence, just trying to finish the last sentence.
Thank you very much. We will, we've listened to the comment. We will read the comment when it comes our way. So thank you for that. And we will move on to our next public commenter, who I believe is Becky Johnson.
Yes, Mr. Chair, I've not been able to locate Becky in the attendees list. If you are in the meeting and could raise your hand, we'll make sure to get you in. In the meantime, we can move on to Kate Merlin.
Let's do that. Looks like Ms. Merlin has been elevated to a panelist. And there she is. Ms. Merlin, if you are ready, you can commence.
Great, thank you. Bill, you're the only one that I can see right now. I hope I'm not talking to an audience of one, although a great audience if that's the case.
I see everyone else on my screen, so I think they can all hear you.
All right,
I see them nodding, so.
Okay. Well, I want to thank you all for taking this longer format comment as your evening meeting tonight. I appreciate your efforts to expand participation by providing alternative opportunities and to make yourselves available to those who may be unable to participate on Wednesday mornings. I appreciate that you've been in hearings all day, and I thank you for your work there as well. There are several topics which are off limits to me tonight, but please understand that does not mean that I do not wish to speak on those topics. Also, please understand that my respect for you all as individuals and for your roles often struggles against my sense of hopelessness and despair, the plight of our citizens, and at our state and the fact that this agency has been in many ways resistant to efforts at reform, at least viewed through the lens of action as opposed to public statements. Put very bluntly, there are many areas in which we've failed to see any improvement since SB 19-181 was passed or since mission change rules were implemented. Some serious issues appear to have actually worsened since mission change. I ask that you seriously listen to the concerns raised by Brad Clefane, who raised issues around procedural timelines and data availability that seriously hinder public participation in a way that could even be construed as interfering with citizens' due process rights, if not the Administrative Procedures Act. But for my main comments, I would like to speak to you again, and I am reading, I can submit these in writing to you later. I want to speak to you again about the financial assurance rulemaking, if that's okay. I believe it was an unfortunate choice to postpone the rulemaking, given the Commission's broad authority to modify its proposed rules as part of the normal course of rulemaking. However, I can respect your choice and your stated belief that the resulting rules will be stronger and more protective of the state. I believe that the COGCC should maintain a status quo position during this period with regard to transfers in particular. And I can submit the legal authority on which I believe you have the basis to do so. I'm seriously concerned with transfers during the prolonged rulemaking period, which could provide opportunities for operators to amend their portfolio structures in ways that would facilitate regulatory evasion. I also wanted to highlight some data that I uncovered during review of the production data from 2020. The Commission's draft proposed rules rely heavily on prioritization of operators who maintain low numbers of low producing wells, allowing them to bond their wells for as little as $1,250 per well under a blanket bonding regime.
Ms. Merlin,
However, at the time
I'm gonna give you a timeout real quick.
Extraction entered bankruptcy, approximately 80% of its wells were in production, and only about 30% of its wells would qualify as strippers.
Ms. Merlin?
Yes.
Um,
Yes.
it-
My
it-
connection's unstable.
It's
Hello?
much better now. It was very choppy and kind of robotic, but I think I heard everything come through, and I'm seeing some nodding from my commissioners as well. You sound much clearer now without video, but I just wanted to stop the clock and give you an opportunity to get that connection restabilized. So if you're ready, we can pick back up where you left off. Ms. Merlin? Ms. Larson, it looks like Ms. Merlin has dropped off the call. I see. Let's give her a moment to catch back up, and then we can pick her back up at the 2 minutes. In the meantime, has Ms. Johnson appeared in the room?
I have not found her.
Okay. We'll give just a few moments for Ms. Merlin to dial back in.
I believe I'm back. Can you hear me?
We can.
And my son. Hold on,
Yes.
but I'm trying to make comments. Sorry. Okay. My first last name is go downstairs and I'll talk to you in 1 second. I love you. Okay, sorry. I just wanted to, I'll try to get through this really quickly. Extraction was in bankruptcy, 80% of its wells were in production, and only about 30% of its wells would qualify as strippers, let alone the much lower threshold of 5 barrels of oil equivalent per day. Industry states that bankruptcy is only a mechanism for corporate restructuring and emphasize that they're lawfully entitled to it, and that bankruptcy is wholly unrelated to orphanage. However, even under such Chapter 11 bankruptcies, many businesses never reemerge, and it's indisputably related to financial instability. Furthermore, Petro's share was among the top 15% of operators per well in 2020, with an average of 26 barrels of oil equivalent per day per well. It went bankrupt and sent all of its wells to the state orphan well program, the cost of which has been estimated to be about $16 million compared to only $325,000 in financial assurances. It appears that the request for additional staff and additional budget would potentially expand the orphan well program between 2 and 3 times. However, the most wells ever plugged by the orphan well program was 60 in a year. There are serious administrative burdens, TABOR constraints, enterprise constraints, and requirements around state contracting, procurement requirements that make it not a feasible solution for the state's problem with the excess number of idle and at-risk wells. I would love to comment to you more. It looks like I'm running out of time. But I have lots of data sorry, I'm also distracted. Thank you so much for listening tonight, and good luck with all of your hearings coming up in the next few days. Thank you.
Thank you, Ms. Merlin. And if you would like to share your written comments with us, we're happy to read those. I also believe you have all of our contact information, so we'll take comments offline as well. With that, did we ever find Ms. Johnson?
Mr. Chair, Ms. Johnson is not in the meeting.
Do we have anyone else on our public comment list?
We do not.
Okay. In that case, now's time for commissioner comments, if we have any. And so I will open it up to commissioners if anyone's got any comments. I'm not seeing any, but I'd like to make a comment just in regards to to this last week that we've had and a long day today. Just a thanks to my fellow commissioners for all the thoughtful engagement and for being present here this evening, for listening to public comment. So anyone we missed today, if you didn't get a chance to make public comment or sign up in time, and you have written comments, we always take those. And otherwise, we will look forward to hearing from you at our next public comment session. With that, I don't think we have anything further. Would anyone like to offer a motion to adjourn? Mr. Davenport?
Mr. Chair, thank you. I think it's appropriate that we adjourn until Friday at, I believe, 9:30 a.m.
Sounds good. Looking
So
for a
moved.
motion.
Second.
All those in favor?
Aye.
Aye. All right, then we will see everybody on Friday at 9:30 a.m. And everyone have a great couple days between now and then.